Uh, Kenny Ray Bean Jr. and for Mr. LeBlanc. Ms. Spose.
Yes, sir.
Okay. This is cause number 24 CCCR 2981, case of style state of Texas versus Kenny Ray Bean. Ms. Bean, is that your full name? Okay, how you doing, Mr. Bean? I'm doing fine, thanks for asking, Mr. Bean. You're represented by your attorney, Todd LeBlanc. Hey, Mr. LeBlanc, how are you doing?
Good, Judge. I'm sorry I'm late.
Okay, I understand that you were in court in Hardin County.
Yes.
Now, Mr. LeBlanc, Mr. Bean's cases are set for trial. What's your announcement?
Judge, we're ready.
And, okay, state, what's your announcement? He's on the trial now.
Yes, sir. Listen, we had him set on our docket for, it's number 3 judge in the state's announced ready.
Okay, we'll just have a seat now. We have a number 1 case. This case is going, well, actually, the number 1 would have been Rife, and then this was number 2. But then Rife is picking a jury in drug court, so number 2 cases on.
Around till y'all.
Yeah, yeah, let him know that once we start picking the jury, you can leave. Okay, and you have Edward Cook. Now, this is only 206 days old.
Cook.
Just have a seat. How you doing, Mr. Cook?
Hi, Mr. Cook.
That's good, Mr. Cook. You're represented in your case by your attorney, Todd LeBlanc. And Mr. LeBlanc, what is your announcement in Mr. Cook's case?
Judge, we need one more. Pause.
Let's talk about this. I have a question mark on my trial. I have a question mark on.
Okay.
So I.
This was-
Can we-
Motion last month, January.
So-
Leave it on trial.
Yeah, that's good time.
Okay, we're gonna leave it on the trial docket. Just reset it. Give us a reset date.
Okay.
Is that all right?
What's this one?
Edward Cook, page 5, trial docket.
It's mine.
Yeah, I just can't remember.
We can do, March 23rd.
No, Matt, no, sir.
No, that's the week he's out.
Yep, not March 20th.
That's the week you're out?
Yes, sir. I only had like that week, I have March 9th, and then again on the 23rd, Judge.
Hmm?
That's all, that's the court dates we gave out.
No.
No, I
it's
think you pushed it
16th.
up a
You
week.
put it right in the middle.
You pushed it up a week.
We should have it from, well, I'm sorry, Judge, it's your docket, I apologize.
Yeah, we'll just have to, that's March 30th, is that okay? Are you going in?
Yeah, no, March 30th, let's see, that's the 20, March 30th would be fine.
Okay. The case will be reset, trial March 30th. You can get your reset. No, you're gonna get your reset and you'll be free to go.
That's that's Cook right here. Yes.
Yes, Edward Cook. And you have, okay, Marcus Edwards. That case is on the announcement document. Marcus Edwards, did we reset that one?
No, sorry. Tell them to come.
Oh. Okay, Mr. Edwards, your full name is Marcus Andrew Edwards. How are you doing, Mr. Edwards?
I'm doing well. How you, sir?
I'm doing fine. Thanks for asking. Now, Mr. Edwards, you're represented by your attorney, Attorney Tyler LeBlanc. This case on announcement. I can wish your announcement in Mr. Edwards' case.
Judge, at a better time, I'd like to speak to the prosecutor. I'm sure he's
Okay,
about it right now, so you can just preset.
let's,
No,
This is a,
no, I don't want to come back.
I've been don't really.
I don't want to deal because I wanted to be this new.
Oh.
that's not gonna happen. This happened as a co-worker in front of multiple witnesses at his place of employment. No offer that we can just set it for trial because the offer is going to be 180 days.
I'm not accepting anything.
Okay,
Okay.
so we need to set it for
or we set it for trial.
I mean, why are you trying to lock me up for something?
That's just his offer. You could accept it or reject it. You don't have to accept it.
Yeah.
Okay, good. Okay, so let's give him a trial date.
30.
Okay, this case is reset for trial on March 30th, 2026 at 9 a.m. Mr. Edwards, you can get your reset from the coordinator. Once you get your reset, you're free to go. And you have a blessed day.
Okay, do I got a chance to face it? I mean,
Yeah, you talking about facial accuser?
whatever y'all call it, I don't know.
Yeah, yeah.
I don't know y'all legal terms.
Okay, well, yeah, you'll have a chance. The person that filed this case against you, they'll be in court. Your attorney have a chance to what we call it, cross-examine, ask them questions.
Mhm.
Okay, you'll have a trial. Okay,
Yeah.
Thank you.
okay, you get your reset and you'll be free to go. Michael Wayne Solis.
You wait till you
It's not cheap, but he said I'll bring it to you outside. We'll see you. Yes, sir.
Yeah, Michael Solis. Okay, he has 3 cases.
Yeah.
And Mr. Solis, your full name is Michael Wayne Solis?
Yes,
All right.
Solis, yes, sir.
How you pronounce it?
Solis?
Yeah, Solis,
Yes,
okay.
sir.
How are you doing?
Good, and you?
I'm doing fine, thanks for asking. Now, Ms. Solis, you're represented in your cases by your attorney, Todd LeBlanc. Mr. LeBlanc, what is your announcement in Mr. Solis' cases?
Judge, we need some more time. This one announced the docket, correct?
Right,
I think this week been able to come before.
so we're gonna reset these for the same day. These are on the announcement docket. Yes,
Okay, the 30th.
You should really take care of that.
okay, these cases will be reset to March 30th.
I thought this March 30th also a trial, jury trial date. I'm just.
That's just a Monday, yeah. I mean, it's just a regular Monday.
Okay.
Okay,
Thank you, Your Honor.
okay. Okay. Reginald Linden. Mr. LeBlanc. Now, Mr. Linden, your full name is Reginald Linden?
Reginald Van Linden,
Okay, how are you doing, Mr. Linden?
spiritually Murray.
That's good. Now, Mr. Lennon, you represented your case by your attorney, Todd LeBlanc. Now, Mr. LeBlanc, if I'm not mistaken, you can correct me if I'm wrong. I think the last time that we appeared in court, you informed the court that you would probably be filing a motion to withdraw. Is that correct?
That's true, Judge. I hadn't filed it. Yes, that's true.
You haven't filed it?
No, Judge.
Okay, so why haven't you filed it?
Well, I just slipped my mind. I didn't see this when I was set for trial in Morgan County. Aggravated kidnapping, so I just didn't. I'll get it filed this afternoon. Need be.
Okay. Okay. Let me see, this is just 141 days.
That's all I'm sure, Judge.
Yeah, it's just 141 days, okay. So,
No objection, by the state if he wants, if he needs to withdraw, Judge. We can defer to his motion, but I have, no
Okay.
objection.
so what we're gonna do, we're gonna have to do a motion to rescind. Okay? So basically, state is not opposing the motion to withdraw. And so instead of him filing a formal motion to withdraw, the court is going to do what is called a motion to rescind the appointment, okay? Which means that he would no longer be appointed on the case. Now, since he's no longer appointed on the case, you still have three options regarding your right to have an attorney. You can, well, first of all, you qualify for court-appointed attorney. Now, if you still would like the court to appoint your attorney, the court can appoint you the next available attorney on the list. Or if you'd like to hire an attorney, you can, your case be reset for you to hire an attorney. Or if you would like to waive your right to have an attorney to represent you, you can do that as well. So in essence, what I'm saying is you still have those three options.
Take another bite of the apple, young.
Okay, so Mr. LeBlanc, you're relieved of your duties and obligations in this case. Okay. Okay, the next,
You think I'll bring it to you? So Lisa. Todd.
okay, Mr. Linden, the next attorney that's on the list is Attorney Langston Adams.
Sergeant Schuler.
Langston Adams is next.
He already got his.
Yeah, this is, Linden is on the pretrial conference delegate.
That's correct.
Okay, Mr. Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
Oh, you walk, please stand in front of the court
I
coordinator.
will.
This is.
Right back.
Okay. Okay, now we have that's Mr.
Wish.
Now Wes, is it Kimler, huh?
Yeah, all right. Right.
Yeah, so Mr. Kimler case, Mr. Kimler is set to put for jury trial in a district court. And so your cases are gonna be reset, okay? He can't be trying two cases at the same time. Okay? So we're gonna give you your recess. Once you get your reset from our coordinator, you'll be free to go and you have a blessed day.
I need to get my trial folder from.
Okay, you can do that.
Yes.
Okay, court will be in recess.
Thank you, Judge. Be right back.
And then we Jefferson County Court at Law number 2 is in session. The court is in session in cause number 24 CCCR 1096. Case of style of state of Texas versus, is that Kent Dane? Kent Dome? Okay. And we have Mr. Dome who's present in court with his attorney, Attorney Waldemar Zuniga.
That's correct, Your Honor.
And the state is present, Assistant Criminal District Attorneys, Attorneys Cornelius Williams, and Attorney Farrah Nixon.
Good afternoon, Your Honor. If you're doing this step.
Good afternoon to you too. Okay, so and state, are you ready?
State's ready, Your Honor.
Vince, are you ready?
That's ready, Your Honor.
And Ms. Bailiff, you can get the panel in.
There's no problem. Thank you very much.
Your Honor, so we verified 18 will not be here.
Yes. Hebner, Mr. Hebner, you're gonna walk all the way down to that first chair. And Mr. Beaver, you're gonna sit next to Mr. Hebner. Right there, the first chair you just passed out. And Ms. Telly, you're gonna sit next to Mr. Beaver. First row. All the way, all the way over there, next to Mr. Beaver. Richardson, you're gonna sit next to Miss Telly. Or Telly. And Mr. Barry, you're gonna sit next to Miss Richardson. Mr. Barrera, you're gonna sit next to Mr. Barry. Ms. Laura, you're gonna sit next to Mr. Barrera. Ms. Sullivan? Ms. Sullivan, I'm here. You're gonna go to that first row of chairs, and then you're gonna sit in that first chair.
Okay.
Over there. And Mr. Smith, you're gonna sit next to Ms. Sullivan.
Thank you.
Yes, ma'am.
And Ms. Jones, you're gonna sit next to Mr. Smith. And Mr. Wheeler, you're gonna sit next to Ms. Jones. And Ms. Drotty, you're gonna sit next to Mr. Wheeler. Mr. Hussein, you're gonna sit next to Ms. Drotty. Okay, Ms. Winters, you're gonna sit next to Mr. Hussein. Ms. Price. Okay, you're gonna go to the second row of chairs, walk all the way down to the first chair, that's first group of chairs, all the way down to the end. Mr. Payne, you're gonna sit next to Ms. Price. Lozamo, You're gonna sit next to Mr. Payne, and that's Ms. Showers. There will be a seat between you and Ms. Lozama. And Ms. Thomas, you will sit next to Ms. Showers. So 20. Okay. Y'all may be seated. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for service as a juror in a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your misdemeanors are normally referred to as your most serious type of offenses. Your misdemeanors are referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and a possible punishment that a person can receive if they are convicted. Now, you will be examined for inclusion on this jury hearing this criminal case. Our courtroom hours vary, but they are normally from 9 a.m. to 5 p.m. However, in County Court at Law Number 2, we usually have dockets in the morning, and a docket is just a list of cases. We have cases in the morning. Like, for example, this morning we had 3 different dockets. One docket was an announcement docket, another docket was a pretrial conference docket, and the third docket was a trial docket. So we had the courtroom filled with people this morning. And so we handle those cases in the morning, and we have our jury trials in the afternoon starting at 1:30. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected for inclusion in this case as a juror, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you'll be permitted to separate yourselves for meals, for recess, and at night. Now, at this time, I must administer to you the first of 2 oaths. So at this time, I need each and every one of you to raise your right hand, and then I will administer the oath. And once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be asked of you by the court or under its directions touching your service, qualification as a juror, so help you God? Please say, "I do." Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you may be considered as a juror in this case. Also, there are certain excuses or an exemption some of you may wish to claim. Now, at this time, I will first determine whether or not you possess the qualifications to serve as a juror in this case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I will ask you a series of questions. I do not want you to answer those questions out loud. I just want you to answer the question to yourself. And then once I finish asking the last question, and the last question is anyone disqualified under the law? And if you think that you may be disqualified under the law, I would ask that you would raise your hand and we will discuss that matter more privately. Now, when I use the term more privately, what I'm talking about is the fact that we have a noise sound device that sounds like this. And I will turn that device on. I will turn the mics off, and we are currently airing on YouTube. And the YouTube will also be turned off so we could discuss the matter more privately. Now, again, I will ask you a series of questions. I do not want you to answer those questions out loud. Please answer each question to yourself. And then at the end, I will ask you, is anyone disqualified under the law? First question, except for failure to register, are you a qualified voter in this county, which is Jefferson County, and this state, which is Texas, under the Constitution and laws of the state of Texas? Number two, have you ever been convicted of theft or any felony? Next question, are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, the next question I'm getting ready to ask, I'm required to ask this question by law. I'm not trying to pry into your personal affairs. I'm just merely following my duty to ask this question. And this question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of this county? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petit juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? Please raise your hand. Okay. Let the record reflect that no one on the panel raised their hands. So at this time, all members of the panel are qualified. Now I will move to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be seated and considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous question to determine whether or not you were qualified. And just answer the question to yourself. And then at the end, I'll ask the last question. And then I'll ask if there's anyone on the panel who would like to claim one of the exemptions. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years? And jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education. Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States Military Forces, serving on active duty and deployed away from Jefferson County and out of your county of residence, Jefferson County? Is there anyone on the panel who would like to claim one of the previous mentioned exemptions? That the record, okay? Okay, we have juror number 10, juror number 12. Okay. Is there anyone else on the panel that would like to claim an exemption? Let the record reflect that no one else on the panel is claiming an exemption. At this time, we'll move to excuses. Now, with the excuses, I'm not going to ask any questions. I will simply make 3 statements. And after I finish making the 3 statements, if there's anyone who would like to claim an excuse based on those statements, then we will have you to come before the bench. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of all the parties, that is, without the consent of the defense and without the consent of the state. And the last statement, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. At this time, all members of the panel are qualified to serve as jurors in this case. Let the record reflect that the time now is 2:38 p.m. on the day's date of February 23rd, 2026. Let the record reflect that the defendant, in this case, Mr. Ket Don, is present with his attorney Baltimore Zuniga.
Good afternoon.
Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney sitting first chair, Attorney Cornelius Williams.
Good afternoon. Thank you for being here. And I'm joined by my co-counsel, Mrs. Dixon.
Okay,
Thank you, Your Honor.
you're welcome. Our court reporter this afternoon is Miss Ada Christie. She's sitting to my left. And Miss Christie will be taking down everything that's being said. So speak up when you are answering or asking questions. The bailiff in this case is Miss Brenda Mosby, and you met Miss Mosby earlier. The defendant stands charged about information with the offense of indecent assault. It is classified as a Class A misdemeanor. And the range of punishment for a Class A misdemeanor, if a person is convicted, minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or the person can be given both such jail time and a fine. And a person may be eligible for probation. Now, the state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. It is, if at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready to proceed?
Ready, y'all.
Is the defense ready to proceed?
Indeed, we are, Your Honor.
Okay. And Mr. Williams, the panel is yours, and I will limit your examination to 30 minutes. Now, if you need additional time, just ask for more time and I'll give you more time.
Thank you very much, Your Honor.
And
Okay.
Your Honor, with the court's permission, can I relocate to the corner of the jury box so I can
That's
see
fine.
all the panel members?
That's fine.
All right, thank you.
I'll be keeping time.
Thank you. May I please call
Yes, you may proceed.
Able counsel for defense?
Thank you. Well,
Yeah.
Judge, since he moved the podium back, I'm gonna move into it.
I mean,
I appreciate it, Mr. Williams.
state reclaim his time, respectfully, Judge.
Okay, yeah, I hadn't started yet. I started, then I stopped. Okay, as soon as you start, I'll start.
Everybody can, I'm Cornelius is fair, Cornelius Williams, Fair Nixon, and we represent, state. Now, the state is not just the government, the state is all of you all. The state is the people. And in my time before you all, what I'm going to try to ascertain, what I'm going to try to learn, in part of what we call this voir dire, is to learn the truth. I just want you guys to speak the truth. You just took an oath. And the oath that you all took for at this juncture is just to tell the truth. Should you get selected for a trial on the jury, then you would take a second oath. But right now, we just want to have a little conversation to see how each of us feel, how each of us think, and how each of us can or cannot follow the law. When I say there's not any right or wrong answers, there aren't any right or wrong answers. Okay, so we're going to begin, and I have to say this case is called an indecent assault. An indecent assault falls under Section 22 of the Texas Penal Code as an assault, but this also has a sexual component. Now, would anyone be offended to hear the use of certain words describing genitalia, acts, sexual acts, or requests for sexual acts, such as like the word fellatio? Would anybody be bothered by the word fellatio or its common term? From the lack of a silence, so no one would be bothered or offended by the use of the term fellatio or a common term. Part of this process for us is to determine what we call biases or prejudice. What is it that you may be against, what you may not like? I can submit this to you, that this case, once again, is indecent assault. The state must be able to show certain elements to abstain and to sustain that offense. The first element is that there is a touching of either the genitals. You may hear common language for, again, genitals, breasts, anus, or other intimate parts. Okay, those are the elements. And it's to gratify a person's, any person, sexual desires. Okay, and the final thing that people would have to say to show is that it occurred here in Jefferson County. Now, with that said, does any member of the panel have a particular feeling about two people being on a date? Two people being on a date. A key element here is consent. Two people on a date. Can one person withdraw that consent? Juror number one, Do you think if two people on a date and a person consents to initial actions, do you think a person can withdraw that consent?
Yes, sir.
Mr. I'm sorry, Mr. Hepner.
Yes, sir.
Let me change my glasses. It's sure it's fun getting a bit older. Now, here we are. Mr. Beaver, do you believe that a person, two people, any person, it could be a man or a woman, people consent to certain action, and then can a person withdraw that consent?
Yes.
Do you feel the same way, Ms. Kelly?
Yes, sir.
How about you, Miss? That would be Mrs. Richardson,
Yeah. Yes, I do.
Mr. Berry.
Yeah.
Mr. Ms. Lauren. Ms. Sullivan.
Yes.
Ms. Mr. Smith.
Yes.
Thank you, sir. Mr. Wheeler.
Yes.
Mr. Hussein. Yes. Ms. Winters. Ms. Price.
Yes.
Mr. Payne.
Yes.
Ms. Lozano.
Yes.
Yeah. Ms. Showers.
Sir.
Thank you. And Ms. Thomas.
Sir.
As I said, there were no right or wrong answers. State appreciate you guys, of course, being candid, being open, and being honest on that. We have a second matter just to briefly discuss. Can we agree that oftentimes things may happen when there's only two people involved? Can we all agree on that? Offenses. Does anyone know of, well, I'm not gonna ask that question. I was going to say an offense that occurred, I don't know, 11 o'clock, church services, church filled with people, somebody walked in and either, assault a person in front of everybody, in front of the choir, in front of everyone. Well, you may have, a few hundred witnesses. I submit to you all that oftentimes in assault or intimate settings, there's only two people involved. Having said that, would anyone need more than the testimony of one witness? And here's the big one, if the state is able to establish beyond a reasonable doubt each and every element of that offense, can you be willing to accept the testimony of one person if the state has proven that beyond a reasonable doubt? Let me go in reverse order. Your number, so sorry. I would say it was one point in time to where I had photographic memory, but that wouldn't be true. And I want for you guys, that's the truth. So, Ms. Thomas, if the state's able to show beyond a reasonable doubt and prove each and every element of the offense of the charge, okay, through one witness, will you be able to accept the testimony and render a verdict based upon a testimony of one witness? Ms. Showers? Mr. Zama?
Yes.
Mr. Payne?
Yes.
Ms. Price?
Yes.
Thank you. Ms. Winters? Mr. Hussein? Mr. Lee? Mr. Smith? Yes. How about you, Ms. Sullivan?
Yes.
Thank you, ma'am. Ms. Laura? Mr. Morrell? Would one be enough? If the elements are shown beyond a reasonable doubt, if they are established from the testimony of one person. Yeah. Yeah. Mr. Berry? Yes. Mrs. Richardson? How about you, Ms. Kelly?
Yes.
Mr. Beaver? And Mr. Henry?
Yes, sir.
Thank you all very much. That is called the one witness rule. And there is, Lord, if you're able to accept, again, each and every element, if the state is able to prove each and every element, you can return a verdict. Once again, it's called the one witness rule. And I appreciate your candor for that. The last thing, there's no instruction in the great state of Texas on what is reasonable doubt. That the reason is that we can all use our common experiences to make a determination. Long ago, I guess when I first started, there was an introduction on what is a reasonable doubt. Now it's not, it's totally up to you all. And you guys will have to use, you guys and ladies, guys and dolls, will also have to use your own common experience, your strength, your hope, your common experience of living within the world. The court will not give you an instruction on reasonable doubt. It will instruct you on the decent assault. It will instruct you on defenses. It will instruct you on all of that. But it will not give you an instruction on reasonable doubt. Therefore, I submit to you all, it's when we make a decision in our everyday lives. You know, I don't know, I hadn't had a chance to look all the way through, but I know most of you guys are homeowners. You know, when you found that right house in that right neighborhood, but before you bought that house, what did you do? Maybe you went there at night to see the neighborhood, to see the house that you guys are looking at. Maybe you went on the weekend to see who the people that were there. You know what? That examination is what the state will present from the stand. That is just like you all making a decision and doing the research. But the research will be done right here within the trial, which would be our crucible where we try to determine the truth. All we will do, we will present the facts to the case to you all. The judge will interpret and present you all with the law, and you all will apply the laws to the facts and then make a decision. Now, again, a decision must be beyond a reasonable doubt. Hold the state to that burden. We welcome that burden. It's not beyond all doubt. It's not beyond all reasonable doubt. It's this, what we use when we make a decision in the most important matters in our lives. Some of us are married. Did I have a reasonable doubt before I married that person? Let me withdraw that question. It's not impossible to make like those decisions. All that we ask is that you be thoughtful, introspective, and apply the laws to the facts. And we will accept whatever verdict that may be. That's all that we ask. But reasonable doubt. It's not all doubt. It's what is reasonable when we make our everyday decision. This is the only opportunity that you guys will have an opportunity to interact with me. At this juncture, does anyone have any questions? At this juncture, does anyone, for whatever reason, think that they might not be able to serve? Once again, we can approach the judge. There may be you touched on religious reasons, but this particular case, if anybody had a friend, relative, either church member or even had been like accused of an assault, any type of assault, then you have to feel free to approach, we'll be able to approach the bench, and we can talk about if we can set that aside and to be fair. That's all that we ask. Thank you all, thank you for your time.
Mr. Zuniga?
Thank you, on completing the court. I feel bad because you didn't take this whole 30 minutes. I feel compelled to give you some of your time back now. I'll try to be as expeditious as I can. Good afternoon again. How long have you been in here? You've been here all afternoon, all day? No, not so bad. Ready to go home? That's all fine. So one of the things Mr. Washington was talking about, and I want to touch on this first, is, I'm sorry. Williams, I'm sorry. No problem, no problem. Well, you know, remembering names is the first thing to go. Remember faces. Mr. Williams.
I'm getting pre-board.
One of the things he talked about, was proof beyond a reasonable doubt, and that's going to be very important in this case. Now, in Texas, we have several burdens of proof, and proof beyond reasonable doubt is the highest burden. And why is that? That's because that's the type of proof that's necessary to potentially put someone in jail, take away their liberty, take away their freedom. So if you were in a car wreck and you went to trial, you'd have something called preponderance of the evidence. Now, all that means, it's a big fancy term that means more probable than not. So if I was Lady Justice and I was the scales of justice, I would just have to tilt one way or the other just a tiny bit to prove beyond a preponderance of the evidence that somebody was responsible or liable in a car accident. Okay? Seems pretty fair, right? One person's more responsible than the other. So the next level of burden in the state of Texas is something called clear and convincing. Now that gets a little bit more serious. If you were a parent and you were divorced and you were in a custody battle with your children, or if you were accused of doing something wrong to your children, a court here in the state of Texas would have to find by clear and convincing evidence that you either didn't deserve your children or someone deserved them more than you. Now that clear and convincing, that's a considerable bigger tilt, because we're talking about the type of evidence or the burden necessary to take your children away from you. Above all of that is proof beyond a reasonable doubt. And as Mr. Williams stated, you're not going to get an instruction on that, but what we know is that it's a pretty high burden. So if we're talking, you know, clear and convincing here, beyond a reasonable doubt, it's not quite all the way up, but it's pretty high up there. Now, I got to tell you something funny. As attorneys, we're pretty vain, so we practice these things before we come and speak to jury panels. And I'll never forget one time in front of the mirror practicing voir dire, and I'm doing my little lady, the scales of justice thing, and my daughter starts singing, "I'm a little teapot, short and sweet." You know, we do think a lot about these cases and how we're going to talk to you and what we're going to talk to you about. So does everybody understand that although we're throwing out these terms, proof beyond a reasonable doubt, that is a considerably high burden? Does everybody agree with that? Okay. Now I'm going to pick on a few people. Mr. Beaver, you went to college, you got a 4-year degree? Yes. Where'd you go to college? Lamar. Okay. Were you did you stay on campus?
No.
Okay. Did you take part in campus activities?
Sure.
Okay. Have any friends that stayed on campus?
Yes.
And did you ever visit the dorms of these friends?
Yeah.
Okay. What about girlfriends? Any girlfriends on campus?
No, sir.
Good for you. Probably finished college. What about Mr. Barretti? Where you finished college with a 4-year degree as well? And where did you go to school? Okay, did you stay on campus? Did you have friends that stayed on campus? You visited the dorms. So you know what dorm life is all about, correct? Great. Let's see, Mr. Wheeler. Where did you go to school? we're on a roll here, aren't we? Did you stay on campus? Okay, but you did have friends as well, that stayed in the dorms, and so you're familiar with dorm life and all that includes, correct? Great. Now, one of the things that Mr. Williams touched on as well, and you guys don't have to answer this to the general panel, but if you want to talk about it, is there anyone here that has been the victim or had a family member potentially that's been a victim of domestic violence or assault or sexual assault? Anybody on the panel at all? Okay. I'm gonna start with Mr. Hebner. Is it something you want that we can talk about here? You'd like to talk about in front of the judge, okay? And who else had their hand raised? Okay, Ms. Tetley.
My
go-
sister was killed by her husband.
And anything about your knowledge of that experience that would cause you to be biased in a case? Who else, please? Yes, Ms. Richardson.
Several things. So.
Are you comfortable speaking about them here? Would you like to talk about
Really
them?
talking.
Gotcha. And Your Honor, would you like to handle these individually or wait till we have everyone and bring them up one at a time?
Yeah, we're gonna do them one at a time.
Okay, very good. Anyone else on the first row? Yes, Ms. Sullivan. Would you like to discuss in front of the judge? Understood. First row, Mr. Smith.
I'd like to discuss with the judge.
Yes, sir. Mr. Wheeler.
Had a parent that was sexually assaulted.
You had a parent that was sexually assaulted and you were at the age of 9 when the time occurred. Anything about that experience that would cause you to feel bias or prejudice in any particular way in the case? I know it's difficult to say because we don't know the facts of this case. We haven't discussed the facts of it, but anything just purely from that experience that would make you feel you cannot be fair and impartial on the jury. Okay. Anyone else? Yes, ma'am. Yes, you do this right. Ms. Lynn. Would you like to discuss with the judge? Anyone on this back left-hand side? Ms. Lasama Hernandez, right? Would you like to discuss with judge? And then, yes, this, I did write your last name down, I'm so sorry. Would you like to discuss with judge?
I mean, I've been a victim, so I don't believe that it would be.
It would not prevent you from being, okay, very good. Okay. So Mr. Williams talked also about the one witness rule. And while it is true in the state of Texas, that's all you need. You have one person that can satisfy the elements of an offense. It's true that that is all a juror need consider. Like if they satisfy all the elements, but can anyone think of the one thing that would be necessary from this juror before you took them at their word? What are some of the things we'd want to know? Whether or not this person's credible. Everyone agree with that? So it's not just a juror who's sworn to tell the truth, but they have to be credible. So that leads me to the next question. What are some of the reasons why someone would lie? Not just to be malicious, but some other reasons. Let's start with Mr. Berry. Can you think of a reason why a person might lie or might embellish, not fully state the facts of something, other than just to be malicious? Retaliation, okay. Anyone else agree with that? That sometimes people might lie because they want to retaliate. If you believe that, raise your hand. Okay. Anything else? What about Mr. I won't pick on you anymore. Mr. Varela, what do you think?
Maybe if they had some kind of relationship, even just maybe or.
Okay, and how did that cause the person to potentially lie if they had a relationship?
Wow.
Like the get back clause, get back at them and say something about something that may not have happened?
Go either way.
Okay, yeah, sure. Anyone else agree with that? Sometimes people might lie because they're upset with the person they were in a relationship with. Sure. What about Miss Sullivan? What about something else? I remember when I was a kid and you get caught with your hand in the cookie jar. You lie because what? Because you're scared? What about being embarrassed about something that happened? Everyone agree that that might cause someone to maybe embellish and maybe not even, like I said, maybe they're not lying to be malicious about something. They're just embarrassed about something that might have happened. Everyone agree with that? Okay. So, there were a couple of you, not picking on you, but Miss Large, you mentioned you had 3 children. What are their ages, please?
Well, my oldest child is deceased, but others are 40 and 37.
Okay, so they're older children. Anyone here that has teenagers? Ah, here we go. I'll start with you. So you have a teenager, how old? Boy or girl? Okay. What does she have any extracurricular activities?
Yeah, art, dance. Hang out with friends.
Yeah, I got a dancer too. My little girl's in Los Angeles right now. She's an industry dancer. You might see her on a couple of movies. Okay, and as a parent, do you think parents are extra protective of girls over boys? See a lot of people nodding their head. Yeah, and we should be. I raised 2 boys, and then when we found out we were pregnant with our third and found out it was a girl, I thought, well, I've done 2 of these, I can do another one, because she was kind of an oops baby. And then she was born, and I realized I had no idea what I was doing as a parent of a girl. She's got me wrapped around her finger, and we're all extra protective of that. So, that leads to a question that just because a person is of a particular gender, do you think they would be more credible than, are girls more credible than boys? Everyone's shaking their head no. Anyone feel that boys are more credible than girls? How we loud. Especially when we're little. So the reason I ask that is because if a witness is a girl, or say let's witness is law enforcement. I know that you worked with PUCJ for a while. If we have an officer on the stand, are you going to give him more credibility over any other witness just because he's a law enforcement officer? Anybody else have any family that may have served as a police officer or know someone in your family, your friend? Okay, so Miss Winfrey, who was that?
5 of
You've got 5 of them. Okay, that's great. So if an officer gets on the stand to testify in this trial, just because he's an officer and just because you have a relationship with 5 law enforcement officers, which is probably a good one, is there anything about that that's going to cause you to believe that witness more than anyone else, just because they're an officer?
No.
Okay. Anyone else related to officers? Yeah. You were.
I was having nephew and brother-in-law,
Okay.
so.
They're no longer serving as officers. But did they retire or they moved on to something else?
Yes.
Okay, and again, I would ask you the same question. Just because they were at one point officers, would that cause you to give more credibility or believe an officer just because he's coming in here wearing a uniform? Okay. And I can tell you that, I've got an older brother and he worked for the feds for about 20 years. And so he and I had some spirited conversations at the dinner table because of what I do as a defense attorney. So anyone else, anyone who has family members that served in the military? Okay. Now, I don't know that the officer who testified in this case has prior military service, but anything about that fact that someone may have prior military service would cause you to believe them over anyone else? Anyone else feel that way? Yes, ma'am? You feel the same? Okay, great. Well, as it turns out, I guess I am gonna give you some of your time back. We really look forward to presenting this case to you, and we just ask that you keep an open mind. You know, one of the favorite sayings that I've heard a judge say is don't leave your common sense at the door when you step into that jury box. Whoever's selected, we look forward to presenting the case, and whoever's not, thank you so much for being here. We appreciate it. Your Honor, those jury panel members, do you want to speak to?
Well, okay, ladies and gentlemen of the jury panel, what we're gonna do now is we're gonna ask that you step outside, and then we're gonna call individuals in one at a time. So at this time, will everyone please stand as the panel exit the courtroom? You can go out either door. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 1096. Case is filed the state of Texas versus Ket Dang. And Mr. Don is present in court with his attorney, Vladimir Zanega. State is present with Assistant Criminal District Attorney Cornelius Williams sitting first chair, and Attorney Farrah Nixon sitting second chair. State, are you ready?
State's radio.
Defense, are you ready?
We are prepared.
Okay. Now, ladies and gentlemen, when your name is called, please go up to the jury box. There are some name tags on the top counter of the jury box. You can pick one and put it on while you're sitting down. So at this time, we'll have Miss Trina Redmond, who is one of the court coordinators in County Court at Law number 2. She's going to call the names. Ms. Redmond?
Jason Hebner. John Beaver. Charlotte Richardson. Michael Barrero. Roger Smith. Jeffrey Wheeler. Andrew Payne.
Okay. Yes.
We need to approach Judge.
Oh. Okay, ladies and gentlemen of the jury, I need each and every one of you to raise your right hand. And please say I do. After I minister to you the second oath, do each of you do solemnly swear that in the case of the state of Texas versus Kent Don, the defendant, you will a true verdict render according to the law and the evidence to help you God. Please say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts comes from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes, or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for that is, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The ruling I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or on television or even in social media about this case. Do not make up your mind about this case until the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. You have badges that you have pinned to your clothing. You'll be permitted to take those badges home with you. Make sure that when you come to the courthouse, you're wearing the badge because those badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who are not selected to serve as jurors in this case, first of all, I would like to thank you for your time and attention. Now, some of you might think that, well, I came down here, I want to sit on the jury, I wasted my time. But guess what? You did not waste your time. And the reason why you didn't waste your time, because as I mentioned to you earlier, in the morning, we had 3 dockets. And one of the dockets was a trial docket. And on that trial docket, there was a list of cases that was set to go to trial here today. However, some of those cases was disposed. And the reason why they was disposed or taken care of is because, sometimes individuals say they would like to they want to go to trial. And they have a right to go to trial. But sometimes people go to trial because they may think that, well, one, the jury is not going to show up or the witness is not going to show up. But on days like today, when people like you take out time from your busy schedules to show up, those individuals have a change of heart. They say, you know what, that offer that the state made to me a few months ago, it looks pretty good right now. And so it was because of people like you who took time out from your busy schedules to come down here, we were able to move cases. So you did not waste your time. And I know that when you came to court this afternoon and you was looking for county court at law number 2, you looked over the top of the door and you saw county court at law number 2, Judge Terrence L. Holmes, and you probably said to yourself, oh, this is Judge Holmes' court. I'm in the right place. But guess what? This is not Judge Holmes' court. This is your court. I'm only a humble public servant serving the citizens of Jefferson County, and you are the citizens of Jefferson County. I've said that to say this. Anytime that you're in the area of Jefferson County Court at Law number 2, please and come have a seat in your courtroom. Now, the area that you're sitting in, you can sit in that area. We call it the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come have a seat in your courtroom and see what goes on in Jefferson County. And I know that you will find it very interesting. Now, the bailiff, she has some letters that she's going to give to each one of you. And before she do that, I usually give everyone a handshake, but we still have COVID in our community, and they said that the flu is pretty bad. So I can't give you a handshake, but I can give you what I call an air handshake. And so on behalf of the citizens of Jefferson County, behalf of the staff here in County Court at Law number 2, I'd like to thank you for coming here today. This will conclude your case, and each and every one of you have a blessed day. You're excused.
There's the road.
Yeah, real quick for the time. Thank y'all very much.
I brought them all. They may have closed their windows.
Thank y'all very much.
Thank you very much.
Thank you so much.
Okay, now, ladies and gentlemen, we're gonna ask that you come back tomorrow. We're gonna start the testimony in this case on tomorrow at 2 p.m. We're gonna have we have a hearing going on prior to that. And so we're gonna ask everyone to please go out and remain in the hallway until the bailiff come and get you. And we make sure everyone is here on time for 2 p.m. on tomorrow. Okay? So at this time, you're excused. You can follow the bailiff out into the hallway. Everyone, please stand as the jury exit the courtroom. And court will be in recess on this case until 1 p.m. tomorrow. Start our pre-trial.
1 p.m. Yes,
1 p.m. Okay. All right. And-
a few minutes, let the jurors get gone before you leave.
Okay, this will conclude the calling of this trial on today's date of February 23rd, 2026. In County Court at Law Number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors and defense, you excuse.
There's not the record.
Not yet.